If you've clicked here from the main video 4, welcome back. And if you've landed directly on this one, know this is a part of a mini-series inside the First Time Home Seller series called Selling When It's Not by Choice. Losing someone you love is hard enough. Facing the sale of their home, whether it's the place you shared with your spouse or a property you inherited, adds a new layer of questions and emotions. It's okay to take your time, to ask for help, to feel what you feel along the way. In this video, I'll walk you through what to expect, who needs to sign, how probate or trust may come into play, what costs you might see, and how to keep the process as clear and respectful as possible. Before diving into specific situations, here are 3 things almost every family should do right away. Confirm who must sign. Is it you as the surviving spouse, a trustee, the executor, or multiple heirs? Remember, a power of attorney ends at death. Gather authority documents. These may include letters testamentary, a trustee's certificate, payoff statements, HOA paperwork, or lien information. And choose a family spokesperson. When multiple voices are involved, things can get emotional and overwhelming fast. Designate one point of contact. That doesn't mean they're making all the decisions. It just helps streamline communication, reduce stress, and avoid misunderstandings. When those foundational steps are in place, let's look at how the process works depending on your situation. Starting with what to do when you've lost a spouse. And now you're navigating what to do with the home you shared. Here's what to check first. Title. If the home was titled jointly with right of survivorship, the ownership often transfers directly to you, and you may be able to sell without probate. Homestead protection. In some states like Florida, a primary residence may still be considered your homestead, even if only one spouse was on the deed. In many cases, this gives you the right to remain in the property or sell the property. But both signatures may be required if you've lived there together for many years. If your spouse was the only one on title, the property usually has to go through probate before it can be sold. Sometimes the judge will allow the sale sooner, but the proceeds are still often placed in a restricted account until the probate is complete. Mortgage and liens. Even if ownership transfers to you, loans or judgments tied to the property don't disappear. Insurance. If the policy was in your spouse's name, update it right away to ensure the property is covered while it's on the market. This can feel overwhelming, but with a good title company and a probate attorney, the path forward becomes clearer, step by step. If the home isn't just yours, but shared among heirs, the process looks a little different. If you've inherited a home, maybe from a parent, sibling, or another loved one, here's what matters most. Will or trust. A will can clarify who inherits, but the property often still passes through probate before a sale. A trust usually allows the faster path once the trustee has certification. Heirs. Who are the legal heirs? Do they all agree to sell? Probate. Has it been complete? If not, the property may not be ready to sell. Belongings. Cleaning out the loved one's home can be emotional. I can connect you with trusted clean out, donations, or estate sale services. Appraisals. Ordering a pre-listing appraisal builds trust among heirs. The neutral number shows the home wasn't undersold and helps preserve family harmony. Condition and disclosure. Estate sales often as is, but you're still required to disclose any material facts you know. If you don't know, simply state that, and that's completely acceptable. When emotions and multiple heirs are involved, things can get complicated. That's where having the right legal support matters most. If probate is required, it's almost always worth consulting a probate attorney, even briefly. They'll confirm who has legal authority to sign, what language must be included in the listing and the contract, and how proceeds should be handled. Once families have a clearer picture of the process, the next question often that comes up, what will this cost? Probate fees, court filing fees, attorney's cost, appraisals especially useful with multiple heirs, repairs or cleanouts, carrying costs like insurance, taxes, utilities while waiting for probate or a buyer, closing costs like escrow, title, transfer, taxes, or HOA fees. And don't forget the agent compensation on the sell and the buy side. The good news, most of those are predictable, and planning for them helps avoid surprises. If you're handling the property out of state, you don't need to be here for every step. A good local agent can coordinate cleanouts and donations, connect you with contractors, cleaners, or estate sale companies, stage or virtually stage the home, handle showings, repairs, and paperwork. And in many states, you can sign and close remotely with a mobile notary. That means you can keep moving forward even from a distance. Because at the end of the day, selling a loved one's home is never about paperwork. It's a part of the grieving process. If you've lost a spouse, letting go of the home you shared doesn't erase the memories you built there. It simply opens space for your next chapter when you're ready. And if you've inherited a family's property, know that with the right support and a clear plan, it's possible to honor your loved one while still keeping relationships intact. If your situation is different, like divorce or financial stress, those are covered in another video in this mini-series. You'll find them linked here in the description below. On our next main video, video 5, we'll cover the question many sellers ask. Should I sell my home or should I keep it as a rental? I'll see you in the next one.